Hello and welcome to the update for any student who is studying a family law module in the academic year 2020-2021. We have one new act and several new cases to get through in this video, as well as one bill that's been held up because of a mixture of coronavirus and Brexit. But before we get to that, I think it's just worth saying that this is a free update that's going to be made available on YouTube for everyone to see. But if you are interested in purchasing the full family law course, then there's going to be a link in the description to this video below. So it's about the same price as a revision guide and should cover everything that you will need to know in a family law module. So without further ado, let's get started with the update.
So the first thing that we're going to be talking about as part of this update is a new statute, and that is the Divorce, Dissolution and Separation Act 2020. Now, this is not likely to come into force until late 2021, but it does make a really important change in the area of divorce law, and so it's definitely worth being aware of, especially if you're potentially going to be writing an essay on this subject. Section 1 of the Act basically substitutes in a new Section 1 of the Matrimonial Causes Act 1973. And that Section 1 of that 1973 Act is all about the facts that are the basis for any divorce. And these can include things like desertion and adultery, but instead of that now, we're going to be replacing those facts of divorce with a simple statement of irretrievable breakdown. And that idea of replacing it with a simple statement has its advantages and its disadvantages as well, so let's think about some of those. The advantages is that it does end that blame game that is a part of divorce. As I said, the current facts at the moment are things like adultery, which is obviously one party blaming another party for the breakdown of the marriage, and that's going to come to an end if it's a simple statement from one of the parties or even potentially both of the parties together. It's also likely to make proceedings much more amicable. If there isn't any blame that's going around, then the actual legal process of getting the divorce is likely to be a bit more friendly and less hostile between the two parties. There's also going to be an extended period of 6 months from the application to the divorce itself, which allows time for reflection and possible reconciliation. It also removes the ability of an obstructive spouse to contest the divorce. Now, in the vast majority of cases, we see divorces go through, and even if there is an accusation of adultery, then that's still not going to be contested by the parties, and it will go through. But there are a small minority of cases that do come through the courts each year where the actual divorce itself is being contested, especially on things like whether there is an irretrievable breakdown of the marriage. And this whole act is designed to stop those vexatious cases. There are some negatives as well, so easier divorces arguably undermines the institution of marriage. This is a very sort of religious-centred argument based around sort of Christian and other religious ideas that marriage is really important, and also culturally in the UK that family life is important and something that should be protected. Obviously, this Act of Parliament undermines that to some extent. However, as I also said, it doesn't really make much of a difference in most cases anyway. If parties are going to get a divorce, this probably won't make much of a practical difference for 97, 98, 99% of them. There's also another question about whether that 6-month period is too long. How many couples do you think are really deciding that they are going to end their marriage and get a divorce, and instead decide to change their mind 6 months later? Really, this is just a sort of delay in the process that's going to prevent quicker divorces and preventing people moving on from their lives as well. Now, that wasn't the only thing that's been going through the Parliament this year. We've also been talking about the Domestic Abuse Bill, which is not an Act of Parliament yet, but hopefully will be in the near future. However, having said that, I think I also talked about the Domestic Abuse Bill in the update from last year, and we still haven't really got that much further with it. In fact, I think that the origins of this bill come from 2017, but it is a subject, domestic abuse, that has got a lot more media prominence in the times of coronavirus. And the reason for that is because at the start of the year, when we had the more severe lockdown, we saw an increase in the number of cases of domestic violence. And that was because obviously couples who maybe weren't getting along very well anyway were all of a sudden forced into a situation where they were living in close quarters, and Whereas before they might have only seen each other in the mornings or during the evenings, now they were potentially spending 24 hours a day with each other. And if there was sort of like an underlying domestic violence element to the relationship anyway, lockdown generally tended to exacerbate that, and so the number of calls went up. So what this bill does, it offers enhanced protection for victims, and that is obviously a must for campaigners who have been looking at this bill as a sort of sign of hope for many years now. However, one of the major disadvantages is that there's limited protection for vulnerable migrants. That tends to match up with the government's immigration policy, where they obviously don't want to encourage immigration in any sort of form. But on the other hand, domestic violence and domestic abuse is a scourge on any sort of relationship and is something where the victim really does have to be protected. And it shouldn't really matter whether that victim is from the UK or if they're from abroad. So what does the bill actually do? Well, for the first time, we're potentially going to get a statutory definition of domestic abuse, which is really important, taking that away from the common law and having it something that's enshrined in statute. We're also going to have things like domestic abuse protection notices and orders, which offer much more immediate protection to victims. So rather than them having to potentially wait and get those orders or notices against their partner, they can now get them much more immediately and get immediate protection. And that's going to make victims much more likely to come forward and use the legal system, which is obviously what we want. There's also going to be more sensitive procedures if a case does go to court. That includes things around how victims are protected and the circumstances in which they will be required to testify and potentially be cross-examined. There's also going to be requirements in the public law sector to prioritise the housing needs of domestic abuse survivors. And again, the reason why this is important is because it's going to encourage more victims to come forward. A lot of the time, the reason that they don't is because they simply don't have anywhere else to go. And if a woman, for example, has children who they also need to look after, then the chances that they're going to have a friend who can put them up, as well as their children too, is very low, and it's also, a potential risk to that friend. So having a secure environment for survivors is really important. This also attacks the rough sex defence as well. Now, this is something that really should have been eliminated in the criminal law case of the Crown against Brown many years ago in the early 1990s, but it's something that again keeps cropping up in the context of court cases, especially in relation to domestic abuse, and it's something that really needs to be attacked further, and this bill would do that. We've also had a lot of case law that's come through, especially in the Supreme Court, over the last 12 months or so, and I've highlighted some of these cases here. So in the matter of NY, it looks at a child's living arrangement with an international element. I think that was especially to do with a couple that was sort of based between the UK and Israel, so an interesting case there. Whittington Hospital and XX is a really interesting case because it talks about the rights to surrogacy, but it's also an element of medical negligence in the context of that case. So really interesting moral questions there that is worth checking out. And a couple of cases relating to Scotland as well. ABC and Principal Reporter is about the rights of siblings in the context of family hearings in Scotland. And Villiers and Villiers is a Scottish case as well, but it's also a jurisdiction dispute, so it's actually a case where part of the divorce was going through in Scotland and part of it was going through in England as well. So I've not really gone into too much detail with these, and you can obviously go and check out the podcast episodes if you want more details on any of those particular issues.
And there we have it then, lots of different things to think about in the context of family law. And I think that if you are working on a family law coursework or exam, then the ability to bring up relevant and recent cases and acts is really useful. Even the ones that aren't necessarily in force yet, if you are able to discuss those types of things, then it's really going to earn you some extra marks and show that you've done a bit more research than the average student. As I said before, the link to the full course is in the description below. That's several video lectures covering a whole range of topics from domestic violence to divorce, as well as other subjects related to children, anything that really could come up in a family law module. I'll be back with more updates in the future, but for now, bye!